As we are just near the finish line of the Karen Read trial, I am shocked that we are here. And after 20 hours or nearly 20 hours of deliberation, the jury is deadlocked. They cannot come to a unanimous verdict. And I'm in disbelief. After everything I've seen since I've been watching this trial since the very beginning, I did my very best to remain unbiased and to look at everything as objectively as I can, giving both sides the benefit of the doubt, waiting to see this evidence come out to prove Karen Read guilty beyond a reasonable doubt. And as I sit here today, not only did I find that there was not sufficient evidence to prove that she was guilty beyond a reasonable doubt, but I also believe that there is evidence to prove that she is factually innocent. So for today's video, I'm going to list the top 10 reasons why I believe Karen Read should be found not guilty. And there are plenty more reasons, but these are just the top 10 that made the cut. And stay for the end, where I will go over the reasons why I believe she is factually innocent. Now, before we get started, let's hear Judge Cannoni give the jury instructions as to what reasonable doubt means.
What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt.
Number 10, the poorly processed evidence. At the very beginning of this trial, it was alarmingly clear that just about every single piece of evidence that was found at this alleged crime scene was handled in perhaps the worst possible way. From the blood being collected with red Solo cups to then being placed in a paper Stop and Shop bag, and zero evidence tape was on this bag to secure it, to then it being placed in the Sally Port where Karen Read's vehicle would ultimately be stored. We also heard that there was no DNA testing ever done on these blood samples. There were 6 red Solo cups and only one, essentially selected at random, was ever tested, but nobody had ever tested to see whose blood that belonged to. And then we get into the clothing that Officer John O'Keefe was wearing on the night that he died. Now, understandably, because of the circumstances and his body being in the snow for so long, his clothing was soaking wet. Now, they explained that this clothing was sat out so it can dry naturally. However, they claimed that it took 6 days for this clothing to dry, which I don't believe that would be the case, especially considering this is the same type of thing that we see throughout this entire trial, was that they did not give sufficient effort to make sure things were done in a timely manner. The same way that we saw at the crime scene where there were pieces of taillight that were found weeks after while the crime scene was completely open. This crime scene was never closed off to begin with, but then they decided to wait for the snow to melt naturally for evidence to present itself. And that's what we see throughout this entire trial, was that not one investigator seem to have any sense of urgency to make sure that things were processed quickly and correctly. Everything seemed to have been put on the back burner to wait for things to happen naturally, when it seems as if, especially considering that the victim is a police officer, that they would have had more urgency to get things done as quickly and efficiently as possible. And we did not see that even a little bit in this case. We saw how 3 weeks after the incident, pieces of taillight were still being found at the scene, even after the CERT team came out on the very next day and searched the entire property, where they said that they were shoulder to shoulder, searching the entire property using shovels and headlamps, everything that they needed to do to make sure that they searched this area as best they could. They even offered to come back when it was daylight, which for some reason was never done. This team was never called back. So the remaining pieces of taillight were found by the very people who seem to have had their hands in just about every single piece of evidence, specifically Trooper Proctor. And as we look at every single piece of evidence, none of it was seen to be handled with the proper chain of custody. Now, with all of these issues, it could be very well that if Karen Read was guilty, all of this is leaving reasonable doubt, because those protocols are in place to ensure that there aren't this many questions, because questions leads to reasonable doubt. Number 9, the missing body. Throughout the night in question, multiple people testified to looking out of the window on a number of occasions when they would see Karen Read's SUV moving a couple of times. We heard from Jen McCabe, Matt McCabe, Julie Nagel, and Brian Albert Jr. all looking out of the window staggering times, and not a single person saw Karen Read back into John O'Keefe. Not a single person saw her even reverse, and nobody saw John O'Keefe's body laying on the ground. Furthermore, we also hear from Julie Nagel's brother, who had 2 other individuals in their vehicle, or in the vehicle with him. None of them saw anything. None of them saw John O'Keefe on the lawn. And as everyone is leaving for the night, not a single person saw his body on that lawn. And that is a huge problem. Now, some of you may say, well, Julie Nagel mentioned that she saw a black blob, but that really is dependent on whether or not you believe her. And I personally do not, for a number of reasons. One, she said that while Jen McCabe was looking directly at her, she mentioned something about seeing a black blob on the lawn, yet nobody else seemed to have heard that. Number 2, she didn't seem to mention that to investigators until 9 months after the incident. Whereas her best friend is Brian Albert Jr., who was the son of a police officer. And you'd think any rational, reasonable person, if they saw a black blob sitting on the lawn, they would have mentioned that as soon as they realized that that black blob was Officer John O'Keefe, but she never did. Furthermore, using the term black blob to describe a body just doesn't seem realistic. So out of all of the people who were looking out of the window, the people who were driving by, and the people who were leaving the party that night, not a single person saw Officer John O'Keefe get hit by the vehicle or see his body or any of his belongings on that lawn. Nobody saw pieces of red taillight. Nobody saw his hat. Nobody saw his shoes. And nobody saw this 6'2", 200-pound man laying on the lawn. And that is more than enough reasonable doubt. Number 8, the undetermined cause of death. The Commonwealth's own medical examiner could not determine whether or not John O'Keefe's death was even a homicide. She specifically said that the injuries to John O'Keefe were not consistent with the classical injuries that you would find when a pedestrian would be hit by a vehicle.
The manner of death has to do with the circumstances under which Mr. O'Keefe sustained those injuries. And I did not have enough information to be able to determine whether those injuries were accidental or not.
So with this testimony, not only could they not prove that there was even a homicide, They cannot prove that there was an intentional murder. That is reasonable doubt. Number 7, the taillight testimony. A Dighton police officer who arrived at Karen Reed's parents' house in Dighton, Massachusetts, he was there when the vehicle was being seized. And this officer is a third-party officer, so he has no ties or connections to the Boston police nor the Canton police officers. And his testimony about what that taillight looked like when they were taking it into custody was very similar to Carrie Roberts' testimony.
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
In that video, you can clearly hear him saying that the taillight had a little bit of damage, but it was not fully damaged. Now, when you look at the comparison of these photos of what the taillight would have looked like when it was all reconstructed versus what the prosecution suggests it looked like when they took it into custody, the description by both the Dighton police officer and Carrie Roberts do not seem to match what they believe the taillight looked like when it was taken into custody. Furthermore, we see this screenshot or the snapshot of the video of when Karen Reed is leaving John O'Keefe's house the morning when she goes out to search for John O'Keefe, and the entire taillight looks lit up except the little portion where it looks like it might have been a little bit broken. When the taillight reconstructionist was putting those pieces of taillight together, they found everything except just a few little pieces. And the pieces that they were unable to find look as if it would be consistent with this photo where the entire taillight is lit up except for the top left portion of that taillight. This photo of her taillight as she is leaving John O'Keefe's home is perhaps one of the most important pieces of evidence to prove that she is not guilty, because the photo of this taillight where it's completely demolished would not have lit up that red if that's truly what it looked like after she hit John O'Keefe. Number 6, the altered video. The prosecution admitted a video into evidence where we see Karen Reed's vehicle inside of the Sallyport.
The video shows police pulling Karen Reed's SUV into the Canton Police Department garage after it was seized as evidence. The video appears to show the passenger side, including the passenger side taillight, which prosecutors say was damaged after Reed allegedly backed into John O'Keefe and killed him.
I testify that this is a accurate scene.
But under cross-examination, state police investigator Yuri Buhenik confirmed the video is actually inverted. It shows not the passenger side, but the driver's side of the SUV. At one point, it shows the driver getting out.
Not once did you mention that this video is actually completely inverted.
I did not know.
How did you discover that the image was inverted?
I saw the word police and thought I had dyslexia.
In the video, the word police appears backwards on another vehicle parked in the garage. So does the number 4 on one of the garage's overhead doors. Here is the video again after we have uninverted it. What is in fact the passenger side taillight is out of view, and there appears to be somebody standing near it.
Who's the guy in the watch cap, in the winter cap, back there by that right rear taillight the entire time by himself? That's Proctor.
Now, throughout the direct testimony, Prosecutor Lally nor Trooper Buchanan ever mentioned anything about this video being mirrored. Now, some people say that this is probably just a coincidence, probably wasn't intentional, and I cannot disagree more. The fact that if you look at Lally's prior direct examinations of all of these other witnesses, he would specifically ask those types of questions. And coincidentally, he never asked Trooper Buchanan if this video was mirrored in any way. The fact that the mirrored image of this video was never disclosed and likely would never have been disclosed if Alan Jackson had brought it up seems incredibly shady to me. Now, in this video, once it's flipped over to the correct orientation, we do see Trooper Proctor standing near, kind of hovering near, the back taillight, the damaged taillight of Karen Reed's vehicle for a substantial amount of time. In this exact same video, we see how there's time lapses where people appear out of nowhere. Again, It just seems incredibly shady to me, and that's why this video gives me reasonable doubt. Number 5, the lead investigator. From the very beginning of this trial, quite literally the opening statements, we heard some vile accusations about the lead investigator, Trooper Michael Proctor. And I've got to say, while I wasn't sure if he was ever going to be called to the stand, when he finally was, it was far worse than I had imagined. We heard about the vile text messages regarding Karen Read to his high school buddies, to his sister, and perhaps the most disturbing, to his supervisors.
During the course of your investigation, your figures of speech include the following. She's a bitch.
Objection.
Is that right?
Yes.
A whack job, correct?
Yes.
A retard, right?
Yes.
Her balloon knot leaks, right?
Yes.
No ass, correct?
Yes.
She's fucked, according to you, right?
Yes.
Ass leaker. That was the word you used, a figure of speech, right?
Correct.
A girl who shits herself, right?
Correct.
And then fuck her, correct?
Correct.
Would you agree, Trooper Proctor, that you have dehumanized Karen Read during the course of your investigation with comments and words like this?
Objection.
I'll give you this one, Mr. Jackson.
Would you agree with that?
I would say based off that language, yes.
Now, the fact that he felt so comfortable using this type of language, texting about this woman to his supervisors, is a very clear indication of the type of culture that this police department consists of. The fact that he feels so comfortable texting these things to his supervisors makes me wonder if he's this comfortable acting like this in front of people. Imagine what he would do when nobody is looking. Now, initially, when he came across this case, he even admitted on the stand that he wasn't sure what happened. He wasn't sure if it was an altercation. He wasn't sure if it was an accident. But 16 hours later, after interviewing just 3 people, which was Jen McCabe, Matt McCabe, and Brian Albert, he coincidentally began hating Karen Read with a passion. He hated this woman. When I hear people discussing this case, many people cannot believe that this entire thing would be a cover-up, because how would so many people be in on it? But here's the problem with that line of thinking. That's not how conspiracies work. Conspiracies work when few people know the truth and they convince everyone else around them that what they are doing is the truth. In this case, hypothetically, Jen McCabe, Matt McCabe, and Brian Albert know the truth, and all they have to do is convince Trooper Michael Proctor that Karen Read is guilty. And let's be honest, coming from the family of a police officer or police officers, there's multiple police officers in this family, that's not hard for them to do. So Trooper Proctor has these people in his ear convincing him that Karen Read is guilty. He's eating up every word they're saying. And he has not only the pressure, but now he has the hatred, the fueled hatred, to make sure that she is convicted. And he is absolutely the type of man to do whatever means necessary to ensure she is convicted. Now, there's this misconception that Trooper Proctor would have to know the truth in order for it to be a cover-up or a conspiracy. And that's not true either. Trooper Proctor may fully believe that Karen Read is guilty because of his own bias. That's how bias works. He fully believes that Karen Read is guilty, and he has the pressure to get this case solved ASAP, as these text messages conveyed. So what lengths would Trooper Proctor be willing to go to ensure that Karen Read is guilty? Would he plant evidence? I believe he absolutely would, because there's something called noble cause corruption. Corruption isn't always framing an innocent person. Sometimes it's believing someone is guilty and doing whatever means necessary to ensure they're convicted, because even though what you are doing is wrong, it's somehow justified because it's convicting the right person. But the problem with that is sometimes it's not the right person. Sometimes you are framing an innocent person because your own bias is making you believe that they are guilty. I truly believe that Michael Proctor was convinced that Karen Reed was guilty. But instead of following the evidence that led him to a suspect, he had the suspect and would find the evidence backwards. And that's not how it's supposed to go. And historically, that is exactly how innocent people are sent to prison. And the fact that Trooper Proctor had his hands on just about every single piece of evidence is more than enough reasonable doubt for me. Number 4, the reconstruction amateur. We were introduced to Trooper Joseph Paul, who was the Commonwealth's supposed expert. Now, very early on, it was clear that this man is not an expert in this field. Instead, he was a trooper with an assignment who took a few classes, and I imagine he probably did not do well in those classes, as he does not understand the basic terminology for the science that he is supposed to be an expert in.
Define kinematics for the jurors.
It deals with the aspect of motion.
It's a subfield of what broader field?
Kinematics.
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Physics, correct?
Yes.
And it describes how points and objects and systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with emotions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity?
Right.
I mean, it deals with motion. It deals with forward, and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
What role does acceleration play in the field of kinematics?
What role does acceleration play in kinematics?
Correct.
It talks about, like you just said, it talks about the speed and talks about motion.
Is kinematics also known as the geometry of motion? Is that correct?
I have not heard that.
Never heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion?
That's what I asked.
Constrained motion. I can't recollect at the moment.
None of the evidence or theories or conclusions that Trooper Paul came to made any rational or logical sense. He said that essentially Officer John O'Keefe was standing with his back facing the vehicle, with his arm out, and he was struck by Karen Reed's vehicle going 24 miles an hour in reverse, struck his arm. The taillight shattered, cutting his arm, yet he had no bruises. And this action, hitting just his arm, was supposed to project John O'Keefe's body, a 210-pound man, project his body 30 feet into the yard, but not before he would first hit his head on the curb. None of that makes sense. And when he is attempting to recite his conclusions, it's very clear that he attempted to memorize them because not even he is confident in his conclusions.
Now, sir, with respect to your investigation, what, if any, opinions did you draw based on your training and experience in regard to this collision and how it occurred?
May I look at my report real quick? Just make sure.
Yes.
Thank you. All right. So, throughout my investigation, this appeared to be a single car collision involving a pedestrian. The vehicle was traveling at a higher acceleration when...
As he is reading this aloud, it reminded me of the scene in The Office.
Line.
I'm sorry, what?
He asked for a line, like in a play.
That's the entire energy I got from Trooper Paul's testimony. He was not even confident in what he was saying, and he did not even understand the term of confirmation bias, which was exactly how his reconstruction took place. They told him what had happened. He went backwards, very similarly to how Trooper Proctor did with Karen Reed. He was convinced she was guilty. He went backwards to find any evidence to prove his own bias. The very same thing we see with Trooper Paul. He was told this is how the accident happened. He went backwards to try to find the evidence to confirm that that's what happened. But unfortunately for Trooper Paul, the science and the physics don't lie. Number 3, Lucky. We were introduced to the snowplow driver, Brian Lucky Loughran. Now, Lucky was assigned to plow the Fairview area on the night in question. Now, as he is testifying, he mentions that he is extremely vigilant of his surroundings as he wants to ensure he doesn't hit any mailboxes, he doesn't want to hit any vehicles, any pedestrians, or any animals. As he is driving by 34 Fairview, which he is familiar with because he knows the Alberts, he unequivocally said that there was no body on that lawn. Not that he wasn't sure if there was, not that he didn't see one. He said he looked on that lawn and there was no body there. No body was on that lawn. And the fact that we heard how none of the investigators reached out to him until after the defense's investigators reached out is very telling, because we heard his supervisor provided the name of the plow driver given to Trooper Proctor, but nobody ever followed up. It was as if they did not want to hear what he had to say, which in a case where there is an alleged hit and run, you would think that investigators would do whatever means necessary to see if they can find a single eyewitness, and they didn't do that. That is reasonable doubt. Number 2, the injuries. During the defense's case in chief, we were introduced to 2 experts, Dr. Frank Sheridan, a forensic pathologist and medical examiner, and Dr. Marie Russell, an emergency physician. Now, Dr. Frank Sheridan said that the injuries to John O'Keefe were not consistent with a typical pedestrian strike, and Dr. Marie Russell testified that the injuries found on Officer John O'Keefe were more consistent with an animal attack.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack.
Now, this woman has had experience with an upwards of 1,000 animal attacks, and she believes that the injuries were far more consistent with an animal attack, perhaps more specifically a large dog. She points out that all of these injuries have a parallelism, which we've heard would not be consistent with this taillight shattering as the prosecution tried to put forth. Now, both of these experts do not need to prove that their theories are correct. However, it does provide enough reasonable doubt that Karen Reed should be found not guilty. Now, while the prosecution has failed to meet their burden to prove that Karen Reed is guilty beyond a reasonable doubt, thus I believe she should be found not guilty, the next 2 experts prove that not only is Karen Reed not guilty, but she is factually innocent. Number 1, the ARCA experts. At the end of the defense's case in chief, we heard from 2 of the most important witnesses in this entire trial, Dr. Daniel Wolf and Dr. Andrew Rentschler, 2 engineers who work for ARCA, which is a private company that was hired by the FBI in an investigation, or the probe that was launched into the investigation of the death of Officer John O'Keefe. Now, these 2 men, perhaps the most qualified experts that you would find in Reconstruction in the entire country, both of them found that the injuries to Officer John O'Keefe are inconsistent with being hit by a vehicle, specifically by a vehicle going 24 miles an hour. And the damage done to Karen Reed's SUV is also inconsistent with hitting somebody.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling 24 miles an hour, sorry, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
Allow it. Watch the leading though.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay.
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5-inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
What was your conclusion with following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck, the taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15-mile-an-hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So while it's two sides of the same coin, both of these aspects are inconsistent with Karen Reed hitting Officer John O'Keefe. Now, the testimony from these two experts is especially crucial because they were not hired by the defense nor the prosecution. They were hired from a third party. So they had no dog in this fight. They had no loyalties to one side over the other. They were just looking at it from a scientific standpoint. They were told the theory of what happened to Officer O'Keefe and to find if it is plausible that it happened as the prosecution suggested. And both of them came back unequivocally and said it is inconsistent. Now, during the cross-examination of Andrew Rentschler, the very last testimony that the jury would hear, this is what Dr. Andrew Rentschler had to say.
Performing that type of an analysis, you could go through and do it, sure, yeah.
And you didn't do it, correct?
No, I did not do it, no. Because, yeah, there's no need in this case. We don't know what happened in this case. There's no indication of, certainly, it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided. Isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
So with all of these reasons, not only do I think that Karen Reed should be found not guilty, but I do think this clears her name. And I do believe that she is factually innocent. And I hope that the jury will return with a not guilty verdict. Now, at the end of last week, we did hear Judge Cannoni ask both the defense and the prosecution if they just wanted to have a hung jury, essentially. While the prosecution wanted the jury to deliberate longer, the defense wanted basically just to give it a hung jury. And many people asked, why would they prefer a hung jury? And the answer is simple. It is better to have a hung jury with the possibility or perhaps likelihood that this will not be retried. But a hung jury is obviously better than a conviction. And because of all of these testimonies throughout this trial, that gives the defense even more ammunition if and when this were to be retried. So again, I hope that the jury will come back with a not guilty verdict. I think that is the only just thing to do. Only time will tell. Juries are wildly unpredictable, so who really knows what's going to happen? But that's just my opinion. Let me know what you guys think down below. Make sure you like this video before you go, and I'll see you guys in the next one.